Good afternoon. Welcome to Managing Risk on Residential Design Build Projects, a webinar brought to you by AIA Contract Documents. Thank you for joining us today. We've got a few administrative items before we get started. This presentation is protected by U.S. and international copyright laws. Reproduction, distribution, display, and use of the presentation without contract documents permission is prohibited. This program is registered for one AIA learning unit. And with that, I'm going to turn it over to one of our presenters, Michael Bamba. Mike, take it away.
Thank you, Hosty. I'll just take a second to thank everyone for taking a chunk of your time out of your day to attend this and talk to us. I'm going to introduce myself real quick, and then I'll have Jimmy do his introduction, and we'll get into the program. My name is Michael Bamba. I'm a Senior Director and Counsel with AIA Contract Documents. I've been with the AIA for 14 years now. Worked on a number of different documents, but Jimmy and I both work with contract documents. We're on staff attorneys that work directly with the Documents Committee in development of all of our documents. So I guess of relevance to this program, I was involved in the AIA's drafting of their their main design build documents, which the residential design build documents are derived from. So we'll be going into more details into the nuances of those documents here in a minute. But Jimmy, why don't you do your introduction, and then we'll get into it.
Sure. Thanks, Mike. So as Mike said, my name is Jimmy Germano. I'm also a staff attorney at the AIA in the Contract Documents program. Before joining the AIA about a year and a half ago, I was in private practice as a litigator representing mostly general contractors, some owners, and some subs in the DC area. And I did that for, litigated for about 7 years after graduating from law school. So with that, I'll turn it back over to Mike to get us started with the substance of the program.
Thanks, Jimmy. All right, so learning objectives, I'll just put these up on the screen for a minute, but we're going to be taking a look at residential design build, focusing primarily on one and two family style projects. We'll talk about some of the other types of residential projects just a little bit, but the focus of this program is going to be on design build and single and two family home construction. Talking about some of the unique risks that are presented there, and we'll kind of use our design build document to illustrate how some of those risks can be dealt with. A little bit of background and just a little bit on our program, the Contract Documents program. We've actually been drafting standard form documents since 1888. So a pretty long time. The image on the screen is of the first AIA contract document. I believe it was called the Uniform Contract, and it was actually an owner-contractor agreement. I don't think we published our first owner-architect agreement until, I think it's 1918. Can't quite remember, but in 1911, the first general conditions document was published. And interestingly, you can actually trace some of the language that's included in our current documents, like in the A201, back to some of the language in those documents. Our drafting process is iterative. We issue a number of drafts, and we have a lot of participants involved in our drafting process. The main work is done by our Contract Documents Committee, but we certainly interface with other industry stakeholders to get feedback on our documents. Our goal is for something that's fair and balanced in attempts to manage risk in a way that is appropriate for a project. Essentially, the party that can control the risk the best usually is the one who gets responsibility for that risk in our projects. And also, we try to shift what we can to insurance. But the whole goal is to make standard form documents that are a useful starting point for the parties to use in, creating that relationship specific for their project. The residential project, when you say residential, there's a lot of different project types. You've got your just straight up single family, and then residential design build is what we're talking about. But you also have multifamily, mixed use, and condominiums. Now we have documents that focus on multifamily and and mixed use and condominiums. Those not really the focus of this program. As I said, we're going to be focusing on residential design build, which sort of overlaps with that single family category. So, what some of the common issues, this is really, the first two are something that occur on just about any project. Unmet owner expectations is essentially the largest focus, the largest cause of claims and disputes on any project. We're going to spend a fair amount of time talking about how, the best way to avoid those types of claims is to have a clear understanding on what expectations are at the beginning of the project, throughout the design of the project, and going into the construction of the project. So if you have clear communication between what the owner is expecting and the design builder understanding what those expectations are, you dramatically reduce the likelihood that there will be a claim associated with that. Now, there might still be disputes or misunderstandings along the way, but if you have a clearly written out owner's program or criteria to reference back to, is the best way to avoid something devolving into what would eventually become a claim. Scope creep and budget obviously are always an issue. Again, focusing on clearly delineating scope of work and all that stuff are important. Something that's probably the most unique to residential construction, especially the single family home type, is special jurisdictional requirements that are imposed by local statute, local code, state laws. And we're going to be talking about those in a little bit of detail later on, and talking about how the AIA's residential design build document allows you to cover some of those requirements. So now I'm going to pass over to Jimmy. Sorry, I hit the button twice there, to talk about some design build just in general before we get into our actual document.
Sure. Thanks, Mike. So in putting this presentation together, we sort of had to assume a general working knowledge by attendees as to what design build is and what it's intended to do. But we thought it'd be helpful to provide a little bit of background in case there are some attendees who may not be as familiar with how design build works. So we're going to take, it's like 3 or 4 slides, and just kind of explain the nuances of design build, what it is, the benefits of it, and how the contracts fit together, and all of that. So first, you have to answer the question of what is design build. And as you can see on your screen, design build is a contracting model where an owner enters into a single contract with a design builder to design and build a project. This is different than your sort of conventional model, where design bid build is usually what it's referred to as, and that's where an owner would hire both a design firm, an architect firm, and then also a contractor, potentially at various stages throughout the sort of the pre-construction phase of the project. And the owner would have a contract, would enter into a separate contract with each of those entities. So that gets us to the benefits of design build. And what we mean by that is there's one contract. So the benefit of design build in general is there's one contract between the owner and the design builder. Typically, there's only one contract. At least that's how it's intended to be set up. The perceived benefit in that regard is that there's a single point of responsibility. So this can be particularly beneficial in the residential space, because a residential owner, maybe a family, may not be as savvy within the industry. So having a single point of responsibility and a single contract makes it a little bit more efficient and easier on that owner to own and be involved throughout the project and the process. And then lastly, it gets the builder involved during early stages of design. So having, on a design build project, having the builder, the contractor portion of the design build firm, having them involved early in the process, for example, why your construction documents, your drawings are being put together, helps to reduce issues that might only become evident later in the construction process when you're dealing with a more traditional design bid build scenario where the architect puts together construction drawings, for example, and the contractor might not see them for many months, or, potentially years later, and then might discover something where there's an ambiguity or maybe something is wrong, and you might have to undo a certain portion of the building or whatever the case may be to correct that. If you're dealing with design build, some of those issues can be taken care of earlier in the process, so it helps to streamline and reduce those amount of those pinch points. With traditional contracts, and what I'm talking about in reference to traditional contracts here are traditional design build contracts. So the more complex design build contracts that the AIA offers. Some of the drawbacks to those in the residential space would be that they, as you might expect, they're drafted for commercial projects, and as a result, they are going to be lengthy. The A141, for example, I think it's well over 30 pages. There's multiple exhibits to fill out, and they are much more complicated than the A145, which is what we're going to talk about here in a minute. The other issue to consider that's a little bit more nuanced is the A141, which is the more lengthy and complicated version of the design build family, assumes that there are other contracts that are being used on the project. And what you're seeing on your screen here is all of the different contracts that can be utilized and are intended to be utilized on a traditional design build job. So you see right at the middle of your screen, the A141, that's between your owner and the design builder. And then the design builder can, unless they're doing the work in-house, can contract separately with the architect via the B143 and a separate contractor with the A142, and both of those would assume that your A201 general conditions are going to apply, and then either the architect and the contractor going down from there can hire consultants and subcontractors, and also the owner, if they want, can hire consultants directly, as you see in the top left. So this contracting scheme, you can imagine each of these agreements being roughly 30 pages or so, A201 being a little bit more than that. This can get very complicated very quickly, particularly when you start adding all of the exhibits, the cross-references, and all of that. And your traditional residential owner may never have seen a construction contract before, let alone one that's that complicated. So the A145 bridges that gap. So the residential design build, the A145, sort of how it's intended to be used is there's one contract. The owner hires the design builder using the A145. So all of those other lines showing the contracts going left and right and up and down are eliminated and streamlined with this one document. So with that, let's get into a little bit of the nuances of the owner design builder agreement for one or two family residential project. And with that, I will turn it back over to Mike to get us into the nuts and bolts of this document.
Thanks, Jimmy. So yeah, so obviously one of the key benefits we see from in the residential space for this document is one, it is a simpler structure. It is a short form. It's 15 pages, which trust me is for us that's pretty short. We could definitely write longer, and it just has one single exhibit, which is the design build amendment, which is when the contract sum essentially gets placed, because the A145, it is a design build contract, so it does involve some amount of design before you can price the project. So, it's a little different than if you have pre-purchased some plans and you're shopping them out to builders. This does envision a design process. So, and the contract essentially lays out a process. And if you were to, have a sample in front of you and look at the articles, they essentially follow what's on the screen now. You get your initial information. The owner and the design builder are going to meet and develop the owner's criteria, which we're going to talk about all this stuff in the subsequent slides. That moves into the design phase. Once the design is set, you'll set the contract sum and time that the design builder is going to work with, create the construction documents, and then you move into construction. So it's a somewhat streamlined process. If you were to compare it to what are like a standard owner architect, which has like the traditional 5 phases of design services, where you have schematic, DD, and and then you get into construction documents, bidding, and then the CA work. So it's a lot more involved process, but the A145 is a streamlined process that's really more conducive to how single-family homes are done. Unless you're going to have a really elaborate design, maybe high-end custom residential, you might be deviating towards some of those more traditional owner-architect type arrangements. But for your standard, more run-of-the-mill type residential design and construction, the A145 is a pretty good fit. So I want to focus first on initial information. It's the first article of the A145, and the reason I want to talk about this is because it's really what sets the stage for a successful project. As I was saying earlier, unmet owners' expectations are the single biggest source of claims. So how do you get around that? You have to have clear understanding of what the owner's requirements are. So in filling out the initial information, the starting point is finding out what the owner's program is, what their budget's going to be, and what kind of design and construction milestones, dates they may have, because those are the things, obviously, that an owner is going to care about the most because they're building their home. They want to achieve certain things in the program. They have a budget that they need to do it within, and they probably need to move in by a certain time. So, and if they can't, they're incurring various carrying costs for wherever they're living at the time while their house is being built. So, all of these things are extremely important, and so to the extent they can be clearly communicated up front, the better off you'll be. Now, that owner's program is going to get further developed as this design process goes on, and we're going to get to that in a second. But I did want to focus on these jurisdictional requirements, because this is probably the most unique aspect of residential single-family home design and construction. It's very different in many ways from commercial construction. Residential construction for 1- and 2-family projects is highly regulated, much more so than commercial projects. And that's because on a commercial projects, the states and laws look at it as a transaction between two relatively sophisticated commercial entities who are essentially in the business and are able to evaluate risk and share risk and things like that. Most states and look at single-family residential construction not as a commercial transaction, but more of a consumer type transaction. And anybody who's familiar with any type of consumer law, it's very protective of the consumer. And that is really the profile that the regulations for single family construction take on. And they vary from jurisdiction to jurisdiction. So, in writing a standard form agreement, we couldn't write provisions that would cover all of the various nuances from state to state, because even within a state, the different counties and cities might have additional requirements, additional protections for purchasers of a custom new home. So what we had to do was add a section in our initial information where a lot of the statutory requirements could be inserted. Now, it's going to require the design builder to have a firm understanding of what all of those additional requirements are, which means they're going to need to consult local counsel. A lot of the states have resources that you can access that kind of summarize what your obligations are going to be. Common ones are communicating lien rights, communicating the warranties that are going to be available to the home purchaser, and a lot of consumer protection notice requirements. I mean, those are sort of the general ones, but we'll talk here in a second actually about some more specific ones just by way of example. But again, it's really this consumer-focused approach to the regulatory scheme that residential construction is subject to. And actually in preparing for this, so I'm a licensed attorney in Maryland. And so we talked, I just talked a fair amount about all these statutory requirements. And I decided I'd do a little research and pull, as an example, see what Maryland required, just to see if I could get a quick handle on it. And as sort of an illustrative effort, let me just kind of go through what I was able to determine that would need to be addressed in a Maryland custom home project. Now, Maryland has something called the Custom Home Protection Act, so you can imagine that it's protecting the homeowner fairly deeply. So there are, and there's about 10 of them I'm just going to list. And this is not a complete list, but in Maryland, if you're doing a custom home project, there are special requirements for how the constructor, which in this case would be the design builder, is going to have to handle the deposit. If it is large enough, it has to be held in its own special escrow account. There are also rules on how and when that escrow account can be accessed. The contract has to include a draw schedule. So you would have to use section 1.2 here to reference and include the draw schedule. Whenever the contractor, the builder, gets paid, within 30 days of receiving that payment, it has to provide a list to the owner of all the subs and suppliers that were paid out of that. This is obviously to protect the homeowner from a lien later on down the road. They have to provide the owner with a waiver of liens from all their subs. There's specific contract language required for what change orders must include. There has to be a disclosure of any third-party warranties, a list of primary subs. There's various disclosures. In Maryland, the builder is actually required to disclose whether or not they've had any adverse adjudications or unsatisfied judgments against them. It has to be listed in the contract. There are minimum performance standards in Maryland. Actually, the Maryland law cross-references the National Association of Home Builders performance requirements. Those are the standards that will be used to determine whether or not the home builder has met its obligations. But the Maryland law notes that local jurisdictions, counties, can raise that standard. So not only do you have to be aware of what the NAHB has published, you need to make sure that you got a handle on the local nuances to that as well. And then there are also some express and implied warranties that regardless of what the contract says, that the state will impose as a matter of right. So that's just 10 I could come up with in the research I did leading up to this. So what I was hoping was that will just illustrate how important this section is and how unique this section is. There's nothing really else like this in any of our other documents. It's this residential document where it's of utmost importance. Next, I'll just talk about owner's criteria. Again, and the reason we're focusing on this, as I said, because owners' unmet expectations is really one of the biggest causes for claims. And one of the focuses on, well, all of our design build documents, even the commercial ones, is preserving the owner's criteria once they're established. One of the major complaints to design build, even though it's growing and growing in popularity, is that when comparing it to more of a traditional design bid build, is that the owner loses control over the design of the project because they're turning it over really to a design builder rather than a traditional architect who's going to be very focused on design. The design builder has sort of that dual responsibility of design and construction, and obviously and they want to control construction costs and design costs because they're looking to make a profit on the whole project. So one of the major complaints to design build is that owners lose control of their project. They essentially give a program, but then they really don't hear a lot from the design builder as they're going through. So in both of our design build documents, commercial and residential, there's a real focus on once the owner's criteria are established to preserve that criteria. So the design stages, now this is design build, so it's an abbreviated design process, not a full-blown, what you'd see in an owner-architect agreement. We didn't want to morph design build into essentially design bid build. We wanted to stay true to the process that's in place in design build. So you'll see an abbreviated design process, but the first step is going to be developing the owner's criteria. So the owner and the design builder will work off of the owner's initial program and establish mutually agreed owner's criteria that will be documented. Once there's agreement there, the owner will issue a notice to proceed. The design builder goes into preliminary design. And that's where the initial design, actual design, will be prepared, and it gets submitted to the owner for approval. When it's submitted to the owner, so you can imagine a process where owner gets a design, looks at it, evaluates it, says it looks good, says move on. But they may not notice, they may not be able to perceive, especially in the custom residential, that certain of the owner's criteria aren't being achieved. So there is a affirmative obligation on the design builder at the end of preliminary design to identify any deviations from the owner's criteria. And the only way for the owner's criteria to be changed is for a modification of the agreement to be issued. So there essentially has to be a change order, for lack of a better word, issued, identifying the change to the owner's criteria. Once there's agreement on the preliminary design and any changes to the criteria, the design builder moves into, essentially it's going to further develop the design sufficient to a point where it can submit a proposal. And that essentially is going to be the design builder's first suggestion of a contract sum and contract time. Now there might be some back and forth between the owner and the design builder on cost at that point. But once again, when you do the design proposal and they submit it for the owner's review, the design builder is again obligated to affirmatively recognize and communicate and disclose to the owner any deviations from the owner's criteria. And then once again, unless there's a modification to the contract, like a change order or the design build amendment, which we're going to get into and Jimmy's going to cover in a second, that owner's criteria is protected from change. So the only way the owner's criteria can be changed, and again, this is what's really defining the owner's expectations, is by direct and mutual understanding between the two parties. So with that, let's get into the design build amendment.
Sure. Thanks, Mike. So as Mike said, I'm going to talk a little bit about the design build amendment. And this is where a lot of what you would think of as your modifications or your fill points are going to take place. But real quick, before I get into that, I actually went through the same exercise that Mike did for Maryland. I'm an attorney as well. I'm licensed among other places in Virginia. And the Virginia requirements, again, just to give you all a flavor of the types of issues to be aware of if you are engaging in a design build for residential construction in Virginia, is the Virginia Consumer Protection Act, for example, is triggered with residential construction, or at least it can be. So the reason why that's important is because I'm sure all of you have either experienced or heard of issues with like homeowners aren't satisfied, and they always have an avenue for a claim via breach of contract, right? But in addition to that, these consumer protection statutes give consumers or homeowners another avenue to go after a general contractor or design builder in the residential construction space, and can add damages in it over and above the damages that would be considered breach of contract type damages. So the Virginia version, for example, has, I think it's $500 or $1,000 per violation, depending upon the nature of the violation. And there's a fee shifting provision, which means that all of the attorney's fees are paid potentially by who would be the design builder in this scenario. There's also specific licensure requirements in Virginia. So there's different tiers of residential or different tiers of construction licenses, and then within the residential space, a design builder has to be licensed at the correct tier, or that could potentially trigger some violations. So again, not an exhaustive list, but just to give you all a flavor of the types of things to look out for in your particular state. Again, the mechanics liens, for example, in Virginia are very specific, and they're actually relatively quick, or they can be, and the statute is worded a little bit tricky. So things like that, some notice that might need to be required to be given to the owner, so that there's no potential other avenues in the event of a potential breach of contract. So just wanted to highlight that for a second before we lose that thought. And then what you're seeing on your screen here is the design build amendment. So it's only 3 pages. It's Exhibit A to the A145, and you'll see there's not a lot of typing. It's a lot of empty space, and that's the point. So the modifications that you would think of as you're going through a more complicated document like an A141 owner design builder agreement, or an A201 or 101, one of the more larger complex documents that the AI offers, those fill points, those modifications can occur in a relatively short period of time, only 3 pages. And the effect that has is really, in the residential space, for an owner, they have to focus their attention here on 3 pages, really only 2.5, of information that they really need to start checking boxes and filling in information. So it gets the parties to focus in on the decisions that need to be made. So in the design build amendment, you're going to be making decisions about the contract sum, which is in Article, it's A2 because it's Exhibit A, but it's Article 2 of the exhibit. And then the contract time is going to be listed in this. The specifications are going to be listed. Identifying the key personnel for the project, and on a residential project, it might be more important for a residential owner to know exactly who on the design builder's staff are going to be the key personnel that are going to be in and out of their, their home, their future home on a daily basis. So those kinds of things are going to be the types of decisions and types of information, types of modifications that might need to be made using this Exhibit A when completing the design build amendment. Once the design build amendment is complete, of course, then you're sort of moving on to the construction phase of the project. And the design builder, as Mike said a couple minutes ago, they're going to complete the construction documents, sort of your more typical CD phase. And then it's important to remember that if you're familiar with the AIA's suite of documents, you might think of one of the more popular ones is like the A101, A201, so your agreement and then their general conditions. There is no standalone general conditions document in the A145. It's all meant to be within this one document, but then of course the design build amendment. But the general conditions, or what you would think of as the general conditions, sort of begin in Article 3 of the A145, and that's going to talk about, from that point on, it's going to start to talk about things like warranties, how changes are made to the contract. So Mike was mentioning like change orders or that sort of thing. The correction of work and how correction of work works, for lack of a better term, within the design build, residential design build space. How contract termination can work, both from the owner's perspective or the design builder's perspective, and then also insurance. So the insurance provisions have a couple fill points just to make sure that the appropriate levels and types of insurance are included within this, what would be considered the general conditions, but again, it's within the body of the A145 document. And we always recommend checking with insurance and legal counsel, because particularly when you're talking about design build, just to give one example, most contractors, especially in the residential space, don't, as a matter of course, carry professional liability insurance. That's typically used when you're dealing with somebody who's like a licensed professional, an architect, a doctor, a lawyer, an engineer, that sort of thing. But in the design build space, that insurance very well may be required and may be prudent to carry, for many reasons. But if there's design build going on, obviously design is part of that. So as you're going through the insurance requirements, making sure that not only are you selecting the right insurance that needs to be carried for this project, but then also checking with your insurance counsel and potentially legal counsel to make sure that from a risk management perspective, you're carrying the right insurance globally for these types of project, even if it may not be required under the contract. So just sort of an aside and things to remember when you're filling out this. And those types of clauses, that's why there's the et cetera down there. Those types of clauses that you would think of when you're thinking about like the A201 document, all of those general conditions, they're going to be abbreviated, of course, in the A145, but that's where they're going to be found as Article 3 on in the document itself. And with that, we are going to talk a little bit about some other possible scenarios to set up this, the single-family home and other agreements that we can offer. But for now, we wanted to pause and see, are there any questions specifically about what we've covered so far before we move on? So, Hasti, if it's possible, if you're listening, are there any questions so far that we can address before we move on? And maybe we'll just kind of pause for 15, 20 seconds to let people get those questions in through the chat if they haven't had time to do so.
Hi, Jimmy. No questions have come in through the chat yet, but we can.
Okay, no problem. Maybe we'll just give people another 5, 10 seconds and see if they want to get some questions in before we move on.
And one of the things I guess to point out in design build, once you're moving into construction, you don't have that same traditional role of an architect where you have an architect working with the owner and overseeing the sort of administering the construction project. Again, it's all going to be in-house with the design builder. So you're not going to have payment application reviews and things like that. Because it's just typically this owner relationship with the contractor, the builder. And again, just to highlight, that's why a lot of these consumer protection laws are so careful with single-family home construction. So, please, we would just want to encourage everyone to, if you're going to be engaging in this type of project, to make sure you have a firm understanding of what your local requirements are. Let's see, so I don't think we have any questions.
So we do. They are coming in steadily.
All right.
Let's get started. So will this presentation expand on insurance?
Yeah. That's a whole other presentation. And we can talk a little bit more about it, but we didn't have much else prepared. I will say that the requirements under this are, the owner is still expected to retain their the traditional type of property insurance. If you're working in our A201, that's usually on a builder's risk type policy. But the owner should be maintaining their property insurance. And we have a waiver of subrogation clause in here. So to the extent the property policy responds, the owner and the design builder will waive claims against one another. And that's just an example of shifting risk to insurance. You're paying for the insurance policy. Insurers, they set their premiums to protect themselves. They spread risk over a number of projects and properties. So hence the waiver of subrogation, which stops the insurance company from, after paying out on a claim, going back after someone else who they say is ultimately responsible. So we have that. Let's see what else is in here. We have standard provisions for workers' comp and employers' liability.
One nuance, Mike, that I can just add is that it's section, if you're following along at home, it's section 16.4 of the A145, and it's a sort of one that skates by. in a lot of contract reviews, but it's important. And it says that each party shall provide certificates of insurance showing their respective coverages prior to commencement of the work. And what that means is that, you know, the owner has to have some insurance under this agreement, and the design builder does as well. And before commencing work, it's a best practice, and not in here it's contractually obligated to exchange basically like the cover sheet, the declaration page, however you want to do it. And just to make sure that all of that insurance has been obtained. And it's one way, just check that box before the project starts, and you may save yourself a whole lot of headache down the road if it turns out that one party didn't obtain certain limits or certain types of insurance, and then you might have a whole mess after the fact trying to figure out who's responsible for that, et cetera. So it's just a way to make sure you've done everything you need to do and the other party has as well. So one little nuance there with respect to insurance, but it's certainly a best practice and a risk management technique to do that. Not only this, but on every project.
Great.
Asti, what else you have for us?
We've got any special concerns using this on alterations and remodels?
No, I mean, it like I said, it envisions a design process. So if you're going to have, if it's the type of, you know, if it's a significant remodel, you can make use of this document. It may be that you know, your local laws, they may not include all types of remodel in the consumer protection style framework, but it may very well. I'm not 100% sure. I know that in Maryland, what I was the list of requirements I was reading from, I think envisioned a whole custom home. So I don't know if a remodel would fit within it. Now, that's not to say that there's still not a regulatory structure, because you know, all home remodels have to be done by a licensed contractor, and usually the licensing laws impose a lot of requirements on the contractors as they're doing them. But there would be, and in my mind, I don't think there's anything that would restrict this document being able to be used for remodels. Jimmy, I don't know if you have any additional thoughts on that.
Yeah, I think you touched on everything. The only thing that I would maybe think of is a remodel may, depending on the complexity of the remodel, it might be more appropriate to have maybe just an owner contractor agreement or like an owner architect agreement separately. Just depending upon if you're doing a relatively straightforward remodel, you might not need a design build full design build workup, but obviously that would depend upon the particular project.
Mike and Jimmy, we also have a lot of questions coming in on the architect's role in this scenario of design build. Multiple questions. I'm just going to read them out loud, see if you can answer them in one swoop. We've got questions about architect-led design build. What is, does the architect's insurance really cover protection for the architect in the construction itself? So maybe you can talk a little bit about the role of the architect and the liability.
In these documents, we're talking about a single entity. It could be an architect performing the design build role. Now I know that certain jurisdictions don't permit a design professional corporation from engaging in construction. So to achieve design build in a quote unquote architect led, you either need to be in a jurisdiction that would allow a design firm to do construction, or the architect would have to essentially create a separate entity that serves as a design builder. The other thing you'll have to be mindful of for architect led design build is that, I think almost all jurisdictions are going to require home contractors to register as home builders. And so there will be a whole other set of requirements that'll have to be met there. Your traditional professional liability coverage is not going to cover construction. So, as Jimmy was going over some of the insurance requirements, if you are going to be engaging in design build, you're going to have to purchase policies that a contractor would typically have. Now, your general CGL policy might cover some, but you're really going to need to contact your insurance broker to build a insurance program that fits your new exposure if you're taking on a design build approach. And that's one of the reasons we pointed out the difference between our more complex design build, where really the role of the architect ends up being as a consultant, part of the design team under the design builder. Here, it's that true single source responsibility. And for the most part, there's no reason an architect can't serve in that role. Traditionally, that hasn't been the case, but there's nothing about the documents that would preclude an architect from being in that role. But, they aren't necessarily performing that job as an architect. They are serving as a design builder. They will have construction liability, and they'll need to make sure that they can perform construction services and be responsible for construction services and can get adequate insurance. You may be required to get bonds from a surety company as well. So you'll need to qualify for that. That's sort of off the top of my head what I can come up with. Jimmy, please feel free to add on to that. Let's move on to the next question.
Sure. Yeah, I'll just add that the Article 16 of the A145 is going to address your insurance requirements, and 16.1.6 specifically requires the design builder to provide builder's risk. And that's, like Mike said, that's something an architect firm may not necessarily have in its standard insurance profile. So that's just one of the things that you'd want to make sure, if it's an architect-led design build effort, that builder's risk is obtained as part of the the risk or the insurance makeup for the project.
And I'm sorry, I'm not sure if you covered this already, but do you then recommend creating a separate business entity, separate from the architectural practice, for design build projects for liability reasons?
That will depend entirely on your jurisdiction and whether or not they preclude your professional organization from doing something other than provide professional services. So it being a case-by-case basis, I'd have to defer on that one.
And this is an agreement between owner and design builder. What about the agreement between design builder and architect?
This document is not set up to have the multiple levels. Now, there's no reason you couldn't use the B143 in our commercial setting to, you'd have to adapt it because, again, it's not envisioned in this document. The assumption here is that the design services will be performed in-house. Now, I think that most jurisdictions do not include design of a single-family home as the practice of architecture. So that obviates the quote-unquote need to have a separate contract with a licensed architect in some instances. But again, those are all jurisdictional specific considerations that you'll have to look into depending on where it is that you practice.
So we do have plenty of more questions. Would you like to continue answering questions, or should we proceed with the presentation?
We can take a couple more, and
Okay.
and then we'll try to reserve a little more time at the end again. But we don't have a lot more to go through, and we can go through it pretty quickly. So let's try to do a couple more questions.
Great. So here's one. Can developers or third-party operators use AIA design build contracts as a base contract between owner and developer / operator, outsourcing licensed design engineer and building professionals under the design build agreement?
I think the question is, can essentially a developer serve as the design builder and farm out the professional services? Is that, Jimmy, is that what you heard?
Yeah.
Yes, I think would be the short answer. Again, the A145 isn't really set up, doesn't really envision there being quote unquote subcontracts or consultant agreements. But there's nothing that precludes it. It just might take a little bit of adaptation to clarify that you're going to subcontract out the professional services.
Then will you be covering in this presentation how to control the level of detail included in defining the owner's requirements?
No, we don't have a specific prepared approach on how to do that. I think that the way the document works is that it kind of envisions a collaborative process to document it. My suggestion as a best practice is that both parties benefit from providing as much detail as possible in developing the owner's criteria, because you remove the likelihood of differing interpretations of if you have something vague, you run the risk of the two parties interpreting a vague statement in polar opposite ways, and that can only invite a dispute later on down the road. So the greater clarity you can provide in the initial information about the owner's program, and then to the extent you can build on that in developing the owner's criteria, the better off both parties will be. So we don't have a specific guide on what the owner's criteria should look like, but I think we would universally suggest that the more detail you can provide, the better off you will be, because you always have that owner's criteria to go back to compare with what the expectations were going to be.
And the last question, which I think you might have already answered, but do you have an agreement to use with the builder?
Well, I suppose you might be tipping our hand a little bit for the rest of the program. Once again, in this A145 structure, it's just the single contract. Now, again, as we said, it's a starting point, and we can't write one agreement that fits everybody's particular circumstances. So feel free to adapt. We are actually developing right now, and it'll be published later, I think next year, some home builder contract where it would be an agreement between the owner and the home builder. So I'll touch on those in a second, but we can. I guess we should actually get back to the program here real quick. 1 second.
And Mike, I would add to that if that question is specifically looking for an agreement between the design builder and the contractor rather than the owner and the contractor, then they might want to look at the A142. Again, you'd have to tailor it. It's not designed to be used, but that could be a good starting point.
Yeah, and that's probably worth pointing out. Whenever we're drafting standard form agreements, and the starting point is usually we have to come up with a set of assumptions, and we try to make the documents consistent internally. We sort of stick to those assumptions. When you deviate, when we fully expect that people will have projects that don't always fit with those assumptions, which is why the documents are fully editable, because we expect that they'll be tweaked to fit your circumstances. The hope is that 80 to 90% of the structure is there for you, and so instead of starting something from scratch, you've got a good framework to work with when you're completing your project agreement. We've kind of gotten into this a little bit already, but we do have other documents that can be used for single family construction, but these are, the ones on the screen here are just owner architect agreements where you're going to have a more full-fledged design process. So these are probably more appropriate for your, and Jimmy, these might be your slides. I can't remember anymore. But these might be for your higher end custom residential where, they're really looking for something unique, and they want to have someone on the project in the form of an architect who's there throughout design, but also is going to have an active role on behalf of the owner in the construction process.
Yeah, and it's important to remember just one thing to note with these. The easy way to remember these is they go as they appear on your screen. a very simplistic way to look at it is the top one, the B105, is going to be your shortest, your most abbreviated, your simplest, and then all the way down the B101 is going to be the most complex. So the B101 is the flagship owner-architect agreement, which, as Mike has referenced a couple of times, apportions the architect services into those traditional 5 phases of services that I'm sure you're all used to. The B101 also doesn't incorporate specifically by reference, but assumes the use of an A201 general conditions document. And like Mike said, the B101 can serve a single family residence project well. It's usually reserved for those that are sort of your very high end, where you're going to need very specific contractual terms. You might have a more sophisticated owner, a very complex residential construction project that needs a more complicated and robust set of architect and design services. You also can just consider the mixed use set of documents that the AIA offers, and those would be 2 of them to look at would be the B109 and the B107. And the B109, there's actually an update coming in the next couple of weeks, I believe, the B109 2020, and that document it's supposed to be used between an owner and architect when there's a multifamily residential or mixed-use residential project. So think of like a high-rise apartment building where the first floor is all mixed-use space, maybe commercial space, something like that. If you want to then convert that document to be used where there are residential condominiums, you would look at the B509. And the B509, it's just a guide, but it goes through and lists some of the specific risks that are inherent with condominium construction and can sort of work through the B109 and say, here's some changes you might consider making, some issues to be aware of. But if residential condominium projects are something that your firm does, even just a review of the B509, and especially when it's re-released here in the next couple of weeks, would be helpful just to be aware of some of those risks, even if they're not applicable to a certain project, just to have kind of an overview. And then the second one would be the B107, and that's the standard form agreement between developer, builder, and architect. When the architect is sort of hired to do limited services for like a prototype single-family residential, perhaps on a larger development where there's only 2 or 3 models of homes or something like that. And I know we had gotten a question earlier about whether there's an agreement between a developer. I think it was developer architect, and this would be one potentially to look at, if not fitting perfectly, maybe to just look at for some terms and ideas to pull out and consider when modifying this or any of the other agreements. And then I'll pass it back over to Mike just to give a preview of those home builder documents he was referencing a couple minutes ago.
Yeah, thanks, Jimmy. And I think this is on this slide. It's a good example, though. We have a lot of different nuanced agreements to deal with some of the specific different structures that architects are going to encounter. Developer, builder. We have program manager documents. We have also a suite of CM documents. So, because a lot of the questions I think were slightly different nuances of project delivery. And so we do have a lot of different options available. So, when if you are coming to our site and looking at the documents we have to offer, do try to look at the different offerings, because there might be something that you weren't necessarily aware of that may fit your structure a little bit better. And again, they need to be tweaked for your particular circumstances, but there may be one that is a better fit for your structure to start from than a traditional B101 or like we've been talking about the A145. So I hinted at this. We are actually in the process now of drafting some home builder documents. We're doing 2 of them. Then I think they're going to be numbered the A115 and A116. They're supposed to come out next year. No one is allowed to hold me to that. It could change. But right now, these are the working titles, and our expectation is that they'll be out next year. The major difference between these 2 is that the A115, it doesn't really include design process. The assumption is that the owner has obtained, either purchased a model set or has independently hired an architect to develop a set of plans. So there is no real design process in the A115. It is really just an engagement of a home builder to build a project. The A116, it's actually quite similar, I suppose, in structure to what we were just talking about, the A145, but it's not a true design builder role. So there is a little element of back and forth between the home builder and the owner to develop like what the real design of the project is. It would be used on projects probably where architectural services are not necessary. To the extent there's engineering, the home builder will, the owner may have to retain those engineering services directly. But it is more of a traditional owner home builder type agreement where there's minimal design occurring. We're really talking about maybe more of your cookie cutter type homes, and the builder, the home builder, is serving that role. So those are two documents we have coming out. There are, again, slight nuances to what we talked about today, but just trying to round out our residential construction program. So that pretty much brings us to the end of our presentation. Jimmy did mention our condominium guide, and you'll be getting a copy of this PowerPoint. So I just wanted to point this out. We have the link to the actual guide itself, but also to point out that we have a Learn webpage where you can find out information about all of our documents. And early on in this, we had shown a document diagram, relationship diagram of the traditional design build, comparing it to residential design build. We have relationship diagrams for all of our families of documents, so you can easily see how they all fit together and what you would need to complete your project contractually. We also have a document content helpline. We can't provide legal advice, but we can offer some guidance on what the original intent was of some of the language in our documents. So again, help you identify possible agreements for you to consider, things like that. So I'll leave this information up. And then if you are using our our products and you have a question about, on the technical side, about how to actually complete something, or you may be having a problem with with one of the services, we have a tech support line as well. So I think that's it. Thank you very much.